Good afternoon, everyone. Welcome to our webinar, Know Your Rights, the California Public Meetings, the Brown Act in particular. My name is Carol Moon Goldberg. I am president of the League of Women Voters of California, and we are very pleased to bring this webinar to you all. As you know, the League is very involved in observing the operations of our governmental agencies. At the local levels, we have observer corps up and down the state who watch their city and county board meetings. They watch their school district meetings, and most recently, they've been watching redistricting body meetings. The Brown Act, which governs the transparency, notice provisions, public participation provisions of local government agencies, is what we rely on to make sure that we can use and see what our governments are doing. Because of the pandemic and technological changes, we have seen some changes to the Brown Act itself. And so the League is very pleased to bring you the First Amendment Coalition. They are dedicated to First Amendment issues, given the name, also to governmental transparency. And they do this through a variety of methods, litigation, and in this case, a webinar such as this. So sit back, everybody, take some notes, and let's turn this over to our guests, the First Amendment Coalition.
Thank you, Carol, and thank you everyone with the League of Women Voters across California, volunteers and community members for joining us. I'm Ginny LaRoe. I'm the Programs and Outreach Director for the First Amendment Coalition. A couple quick announcements. Recording is on. This recording will be emailed to everyone who registered. Closed captioning is enabled. The presentation today, our slideshow, will be linked in your post-event email. We hope that's a service to you, and you can always email me if you need something else. My colleague, Suzanne Ito, our communications director, will be placing helpful links in the chat as we go. So when we mention a resource or something that's online, she'll be sharing those links with you. And also a special thank you to Jennifer Jada Wagner, former San Francisco League president and former California League president, for nurturing this collaboration between our two organizations to bring you this webinar today. Quickly about FACT, the First Amendment Coalition. We're a nonprofit organization working statewide across California and sometimes beyond to advance and defend free speech, free press, and the public's right to know. As Carol mentioned, our work includes litigation when necessary, legislative oversight, and educational programming, and that's what brings us here today. So briefly, I want to just recognize that I see names from all over the state, from Shasta and Siskiyou County, Del Norte, down to Imperial County. We are here as a resource to you truly statewide. And in fact, our strategic plan calls for us to make it a special effort to increase our reach into communities that we may have not been as active before. Places outside of the San Francisco Bay Area, really to bring our open government resources, our civic engagement and programming to you to be a supportive partner for you as you do your volunteer and community work to make government more accessible for the whole community. I also want to just mention as a programming matter for Q&A, you're welcome to use the chat or the Q&A, and we will pause periodically to look for things we can clarify and to answer your questions as we go. Anything we don't get to that is on topic with open meetings in California, we encourage you to send to our legal hotline. We'll be sharing that link. And we'll be trying to also note questions really on topic that will take some more research that we will follow up with you after. My colleagues are monitoring for questions that would require some additional work that we couldn't answer live today. Okay, so now I have the pleasure of introducing you to my colleagues, the real experts, the real Brown Act experts on our staff at the First Amendment Coalition. First, we have Monica Price. She is a legal fellow zooming in from San Francisco. Monica is going to share some of the resources FACT has available to you at no cost. And she'll walk you through some of those ways because this is the beginning of a conversation, not the end. And leading the presentation today is David Loy. David is our legal director. He is a veteran lawyer who has worked on open government and First Amendment issues for many years. David is zooming in from San Diego. You may recognize him from his work with the ACLU, Foundation of San Diego and Imperial Counties, where you worked previously as legal director. And we have a lot of content to cover, so I'm going to turn it over to David, and please take it away.
Thank you, Ginny and Carol, and to the League. When I was at ACLU of San Diego and Imperial Counties, I had the pleasure and privilege to speak to the San Diego chapter of the League, and I enjoyed that greatly and always find these events instructive and enjoyable. So I'm happy to be with you again today online. I'm going to walk through this outline, discuss accessing and participating in public meetings in California. A couple of prefatory remarks. I'm delighted to see there's questions already populating in the Q&A, and I welcome questions. I love questions. I'm always more interested in dialogue than monologue. In today's presentation, I can sort of hit the high points of Brown Act principles. I can discuss, how these rules apply generally. I really won't have the bandwidth to get into the weeds of particular questions as applied to particularly unique facts. That, as Ginny said, we welcome those questions through our hotline, where I can sort of give more detailed attention and review the facts in more detail before sort of setting out the principles that would apply to those facts. So today I'm going to hit the high points. I cannot possibly cover everything about the Brown Act, but if we don't get to your specific question on specific facts, please do send it to us through our hotline, and that link will be part of the materials, and I'm sure in the chat or Q&A at some point. My other sort of second sort of preliminary comment is that, there's always a gap between the letter and spirit of the law, but I'm not sure that gap is larger in any other area than in the Brown Act. The Brown Act, spirit of the Brown Act is about commitment to open meetings and transparency, but the letter of the law is what governs what agencies must actually do. And so to the extent I'm commenting on the act, I'm going to discuss the letter of the act and what it legally requires as a bare minimum. So please do not take this as an endorsement of anything that agencies may do that complies with the letter of the act, even if it violates the spirit of open government and transparency. My goal here is to educate and empower with knowledge about what the law actually requires, not what it ought to or perhaps should in a better world. So with that, let me talk about the foundations for the Brown Act and transparency in California. One thing that's important to know on our next slide is that access to public meetings is a constitutional right in California. The people have the right of access people have the right of access to information concerning conduct of the people's business, and therefore the meetings of public bodies and the writings of public officials and agencies shall be open to public scrutiny. This is the cornerstone of democracy in California. This is above and beyond what the First Amendment requires as a matter of federal law. The First Amendment guarantees your right to speak and criticize government, but it does not necessarily require local governments to follow any particular process. This is why we have a constitutional right in California under our state constitution. And the Brown Act itself amplifies this and makes very clear the people of the state do not yield their sovereignty to the agencies which serve them. The people in delegating authority do not give public servants the right to decide what is good for the people to know and what is not good for them to know. The people insist on remaining informed so they may retain control over the instruments they have created. This is the law in California. This is the governing principle, the overarching policy of the Brown Act. Government agencies serve the people, not the other way around. They work for you, not you for them. Now, how that gets played out, obviously we'll discuss in more detail, but it's very important to remember this. I know often the agencies and governments treat public participation as a burden or inconvenience. I would argue it is a feature, not a bug, that the people have the right of oversight and transparency and ultimately control, however inconvenient that may be to bureaucrats and officials. So let's get into what the Brown Act actually applies to. The Brown Act is a California law that governs local legislative bodies, how they must conduct their meetings. Local legislative bodies include things like the Board of Supervisors, City Council, School Board, Water District, Police Commission, Planning Commission, local agency bodies. Now, there are other governmental agencies and bodies in California that are subject to open meetings laws other than the Brown Act. So, for example, there are state agencies like the California Public Utilities Commission, the California Legislature, the California courts. Now, their proceedings are typically open to the public in various ways, but technically they are not covered by the Brown Act as such. Instead, they are governed by other laws. So state bodies are governed by something called the Bagley-Keene Act, and that's sort of the state level counterpart to the Brown Act. That's things like the PUC. The California legislature is governed by its own set of laws and rules. The California courts are governed by their own set of laws and rules. And so they are open in the same way in spirit and principle, but they're not technically covered by the Brown Act as such, which applies to, again, local legislative bodies and local governments. So this gets us to the question, how do we know if the Brown Act applies to a certain legislative body or committee? That's something we're going to discuss. The Brown Act itself contains a detailed statutory definition of what is a legislative body, and it includes, but is not limited to, the governing board of the agency, be it the city council, the school board, be it the board of supervisors, and what have you. There's also a number of other committees, standing committees, and so forth that can be subject to the Brown Act. For those who want to parse this for themselves, it's California Government Code section 54952 has a highly detailed technical definition of what is a legislative body. We won't get into all the weeds of that. As we walk through the slides, we'll get into the high points. So let's move ahead. So when you have a meeting of a legislative body, and a meeting is, any congregation of at least a majority of the members of the legislative body to hear, discuss, or deliberate agency business. That meeting must generally be open to the public. And generally speaking, actions taken in violation of open meeting laws, such as the Brown Act, can be declared null and void in certain circumstances. This is key again. And the principle here is that we don't have secret government. We don't do backroom deals in California, or ideally anywhere. But in California, a legislative body such as a city council, board of supervisors, school board, what have you, they cannot make decisions in secret unless there's a very narrow exception. They have to meet in public, they have to take votes in public, and they have to comply with all the rules of the Brown Act to make their actions valid and binding. So on our next slide, these are the key rules here. Again, as I was sort of alluding to a minute ago, key provisions of the Brown Act. Agencies, before they meet, they must post an agenda. And that agenda typically must be posted at least 72 hours in advance of the meeting. Now, there are exceptions. Special meetings can be posted 24 hours in advance. Emergency meetings in bona fide emergencies on even shorter notice. But the basic rule is that the agenda must be posted at least 72 hours in advance most of the time, and only topics that are listed on the agenda can be discussed and voted on. The votes must generally be public, either taken in public, or if it was legitimately done in closed session, reported out what the vote was. This is fundamental to accountability and transparency. We do not allow secret votes of legislative body members. Those who are elected or appointed to our legislative bodies are required to disclose how they vote. You and I, those of us who are allowed to vote in California, we can vote secretly and cast a secret ballot for who we want to hold office. But once those people are in office, they have to disclose how they vote on any given item. And agencies cannot require you to sign in as a condition of attending and watching a meeting. If you want to sign up to speak and give public comment, for purposes of managing the queue, so to speak, of who is signed up to comment in what time period, one can be required to give at least some identifying information just on the sign-up log, so they can call you in order of when you're due to speak to the body. Some people who prefer not to give their real names may give a pseudonym or another identifier As far as I know, that is allowed. You're not required to give your real name to speak to an agency. But they cannot require you to sign in or give your name as a condition simply of watching the meeting and listening in, whether online or in person. I saw one quick question in the chat. I'll try to address these as they come in. Somebody asked if the Brown Act, if this applies to agencies elsewhere in the United States or only in California. The Brown Act itself, I'm talking about what applies to agencies in California specifically. Other states may have their own versions or similar laws that require their agencies to hold open public meetings. I have not done a 50-state survey, but I believe most, if not all, states will have similar laws, and these similar overarching principles may apply in other states and jurisdictions. Today, I'm talking here about the Brown Act, which applies only in California. So a couple other key provisions of the Brown Act. You are allowed to record the meeting as long as doing so is not disruptive. The agency may or may not make its own recording, or may not post that to YouTube or wherever. If the agency makes its own record, you are entitled to view and listen to that recording, but you're also allowed to make your own if you wish. I see a quick question, copies of PowerPoints. That goes to copies of documents that may be presented at the meeting. We may address this later, but typically if there is a document, be it a memo, be it a PowerPoint, be it a slideshow, what have you, that is disclosed and used in the meeting, the public generally has a right to access that document unless it's independently exempt from disclosure under the Public Records Act. For example, an attorney-client privilege memo. As far as whether this PowerPoint be available, I'll defer to Ginny and Suzanne on that. I'll let them answer that in the chat. So other key provisions here of the Brown Act. We go to the next slide. I mentioned earlier, there are very limited circumstances when a legislative body is allowed to go into closed session. And they are detailed in the act, and there's a long list of them, but I'll give you just a quick example. When an agency is being sued or is at significant risk of being sued, the governing board, say, for example, the city council, it is allowed to go into closed session to get confidential legal advice from its attorney on the same basis as any private party is allowed to speak to its attorney confidentially. There's provisions for how that must be noted on the agenda and what must be disclosed or reported out. But the basic rule here is the default presumption is that all parts of every agency meeting must be open to the public, except for very narrow circumstances in which a closed session is allowed. And as I mentioned a moment ago, an agency must treat all documents distributed to all or majority of the members as public. For example, staff reports, memos, PowerPoints, what have you, and make them available to the public unless, again, they're exempt under the PRA. So, for example, if the city attorney writes a confidential memo to the city council saying, you're about to be sued and this is how and this is why and this is your exposure, these are your risks and strategies, that memo is probably subject to attorney-client privilege, just for example. So I'm going to pause here just for a quick minute. I know we've seen a lot of questions and try and catch up here.
Yeah, well, I would just say a lot of the questions are going to be answered as we get going, especially about the details of teleconferencing, remote technology, some of the policy concerns that we share, about internet accessibility. And so let us get through those teleconferencing portions of the presentation, and we can go a little deeper into that. A lot of questions about agendas. So, for instance, Parisa says, agendas for normal meetings are required to be posted 72 hours prior to a meeting. Public documents presented or each agenda item are they subject to 72-hour rule 2 under the Brown Act?
Sorry, run that by me again.
Yeah, so you know how agendas, the bare minimum, posted 72 hours prior to a meeting is the kind of baseline. Okay, what about public documents presented under each agenda item related to the—
Oh, like a staff report or a memo, that sort of thing. I don't think the Brown Act requires that they are posted in advance. I think that that is often done as a matter of course, and I think that's best practice. but I'm not sure that the act requires that the staff reports and so on be posted with the agenda. The agenda just has to give a brief general description of each item under consideration. Now, if staff reports are given at the meeting, you have a right to access them afterward. You can certainly make a public records request for them, but I don't know that the letter of the act actually requires that the staff reports be distributed in advance. Although I know many agencies do that as a matter of course, and certainly as a best practice.
Absolutely.
I saw one quick question in the chat. We talked, I think this is on point to what is a meeting. So one question was, are there limits on what can be the topic of a special meeting as opposed to a regular meeting? And generally speaking, the answer is no, except that there's one provision in the Brown Act, I think, that says something that special meeting cannot be called to set the salary, compensation, or benefits of executive level officials. But otherwise, I'm not aware of any other limits on the subject matter of a special meeting. Although special meetings are limited, the only thing that can be discussed in a special meeting is the topic, is that one item of business. They can't amend the agenda. And so special meetings are limited, but I don't believe that there are categorical limits on what can be addressed in a special meeting, with that one carve out that's in the act about compensation of executive officials. I saw another question about what about can members of a governing board like the city council socialize outside the meeting? And the short answer is yes. A meeting is defined as a gathering of a majority of the members of that body to discuss agency business. So if, let's say, you have a 5-member council and 3 members go out for dinner and talk about the weather, they talk about sports, they talk about their kids, what have you, that is not a Brown Act violation because they're not discussing public business. If they do discuss public business, that would be an improper meeting. And improper meetings don't have to be in person or simultaneous. The Brown Act prohibits what's so-called serial meetings, S-E-R-I-A-L, serial meetings, whereby let's say a majority or quorum of the council was to have an email chain or a text chain or a telephone chain discussing agency business, discussing a particular item and coming to some agreement, or even just discussing it outside of a notice meeting. That would also violate the Brown Act. So meetings are a majority of the board to discuss agency business outside, outside of a regularly noticed time. That would violate the Brown Act if it was done.
And David, just in the interest in time, lots of folks have questions about stuff that we're going to jump right into with public comment.
Sure.
So let's get through some of these. I think this will help clarify some of the thorny issues.
Yeah. So public comment, this is a huge area of controversy under the Brown Act, where, I mean, people understandably want to have the right to participate in their government and make their views heard, in person or online to the governing board. So the Brown Act does guarantee the right to address the legislative body during its meeting in real time. They may allow, but they cannot require you to submit written comment in advance. You have a right to speak about an item before or during the time that the governing board is going to consider that item, such as a proposed ordinance or resolution. You can speak about topics not on the agenda if you wish. Many agencies have a sort of non-agenda comment time, but if a topic that you're speaking about is not on the agenda, they can't really respond or address it because it hasn't been noted. So if you want to say propose an ordinance that's not on the agenda, you can certainly go to non-agenda comment time and say your piece, and they can sort of listen to that input, but they can't actually discuss it, except maybe to refer it to staff for further development. But you have the right to speak on that item. Now, there are limits as a practical matter. It's one is that comments can sometimes be limited as to content or topic, so as to matters within the agency's jurisdiction. For example, the school board doesn't necessarily have to allow comment about the city's potholes over which it has no control, or the city council doesn't necessarily have to take comment on educational matters within the school board's jurisdiction. The other thing is if you're speaking about, or if the legislative body is considering a particular item, let's say you're on item 1, an ordinance about potholes, yeah, and the time allotted is to comment on item 1, which is about potholes, the city council doesn't have to necessarily take comment about item 4, which might be about garbage collection. So you can address item 1, pro or con on the pothole ordinance at that time. And if you want to talk about the garbage collection ordinance, you got to wait till item 4 comes up and discuss it at that time. So they can certainly direct people to limit their comments to the item at hand if it's on the agenda at that moment. There's also limits on time and manner of public comment. So the Brown Act does have a provision allowing reasonable regulations, including but not limited to regulations limiting the total amount of time allocated for testimony on particular issues and for each individual speaker. The act essentially says, the council meeting, the city council, the board of supervisors, have the right to set reasonable time limits so that, meetings do not extend indefinitely for days or weeks.
David, a couple details on that. Folks
Sure.
chimed in, I think, are very on point questions. Can the agency or board reduce the time people are allowed if, say, they start the meeting and say it's 4 minutes, and then they say, okay, let's cut it down to 1 minute or something? Wendy, thank you. Wendy Fry in San Diego, thank you for sharing that question.
Yeah, sure. So I'll address that in a second, but let me just set the general rule that, agencies can impose time limits. Typically that's 1 to 3 minutes per speaker on any given item. Yes, the presiding member of the agency or the governing board does typically have discretion to control the flow of a meeting within reason. So if an item is particularly controversial and attracts, let's say, hundreds of speakers, I've actually participated in meetings where this has been the case. They've had to cut the time back from 2 minutes to 1 per speaker to make sure that the meeting doesn't go, all night. So it's not necessarily improper to do that. It's going to depend a lot on the facts and circumstances. It will have to be done even-handedly across the board. They certainly cannot pick and choose, give more time to people on one side of an issue or more time to friends and allies or contributors and so forth. So yes, they can set an overall time limit. They can also say, sometimes they ask people, not to repeat something that's simply been said already, but maybe sort of, submit a slip or say you agree or disagree with previous speakers. But again, the linchpin here is reasonableness. The agency is allowed to exercise reasonable discretion to limit public comment, balance the need for public participation against the need to, conclude the meeting in an orderly manner and not stay there, all night to get it done. What that's going to turn out to in any given circumstance is kind of in the eye of the beholder, right? I mean, what I think is reasonable, what you think is reasonable might be different from what a court says would ultimately be reasonable. In legal terms, reasonableness is a fairly deferential standard. Courts will tend to defer to the judgment of the presiding member or of the board who's, on the spot, as it were, in the meeting. If the board sort of arbitrarily heard 3 speakers and say, you know what, we're done, I don't want to hear from anybody else, too bad, that would probably be unreasonable. But if they cut you back from like 3 minutes to 1 minute, 2 minutes to 1 minute, and give everybody their chance to speak, I doubt seriously that would be a court would find that's a Brown Act violation.
And David, another question, kind of separate from the time limits, you alluded to this, the number of individual speakers. So Chris Gilbert asked, just for a little clarity, can they set an arbitrary number of speakers? Again,
I've seen this actually come up in various agencies, whether it's an aggregate time limit, which is in effect a cap on the number of speakers, or an outright cap on the number of speakers. That's a tough call. It's going to depend on the facts and circumstances. Again, the Brown Act allows reasonable regulations, including but not limited to time limits. So courts do have agencies have a fair amount of discretion as to how they slice that pie. So I can't really give you a categorical answer on whether, a cap on number of speakers or an aggregate time limit is permissible under the Act. I think it's if you'd have to look at each agency's rule, assess it in the context of those facts and circumstances, but bearing in mind the legal understanding of the term reasonable signifies a lot of deference that the courts would generally give to agencies and governing boards to manage the meetings. So I wish I had better news, because obviously, we favor strong public participation. Democracy is time consuming. Democracy is messy sometimes. And, obviously I would suggest personally that one should always err on the side of over inclusion, err on the side of more engagement, more transparency, more participation. But I can't guarantee that a court would always agree with that at the margins. It's a bit of a challenge. So it is a common problem. I've seen this come up quite a bit.
And another follow-up question, and this may again be fact specific, but one of our guests asked, is it okay for a city council meeting to disallow public comment for an entire agenda item, with the stated reason being because public comment has been held at the committee level?
No, I do not think so. If an item, let's say an ordinance was before a committee, and that committee held a meeting which, subject to the Brown Act, had public comment, let's say the committee approved the ordinance and sent it to the full council. Once it comes before the full council for the council's full vote, the council, I do not believe the council cannot disallow public comment entirely, right? For a number of reasons. One, because the Brown Act says you have to have the right to comment on any item that is before a legislative body. Two, people might not have been able to attend the committee meeting. Three, views might change. Four, the ordinance might be somewhat different, or the stakes might be higher. Not every council member who is on the full council might have been at the committee meeting and heard all the public comments. So for all those reasons, no, I do not think that a city council or governing board can disallow comment entirely just because a committee previously considered the same item.
Can we move forward and talk a little bit about language access?
Absolutely. So again, this is an area where I think the spirit of the law lags behind its letter. The Brown Act does not require the government to give you an interpreter or provide its own interpreter or translator. However, you have the right to be heard through your own interpreter, be it a friend, family member, or someone retained. And if you need an interpreter to speak to the governing board or give your comment, the Brown Act does require the agency to allot you at least twice the minimum time that would otherwise be allowed. So for example, if the agency has a rule that says comment is 1 minute per person, but you need to use a translator or an interpreter, you're entitled to 2 minutes. Unless the agency or the governing board is using simultaneous translation equipment. So for example, if they had their own interpreter, on the headpiece who was simultaneously translating or interpreting, the comment from, let's say, Spanish to English, they would not have to give you the extra time. But if you've brought your own interpreter, the agency doesn't provide one, and you're speaking, for example, in Spanish, and your interpreter is translating to English, you're entitled to double the amount of time that is otherwise allowed.
All right. You've been talking about the state law minimums, what the Brown Act requires. I know there's some representatives from the San Francisco Sunshine community here. Can you talk to us about minimums versus additional access? And
absolutely. Yeah, the Brown Act is a state law minimum that all local legislative bodies must follow, but nothing in the Brown Act precludes agencies from going beyond the minimum. They can post agendas earlier. They can provide more public comment time. They can voluntarily agree to provide interpreter services. They can voluntarily post their staff reports in advance. They can do anything they want over and above the minimum, as long as it doesn't violate the minimum floor that the Brown Act requires. They are certainly free to go above and beyond the minimum. Yes, every agency is going to have, and the Brown Act sets outer limits. It's not going to micromanage every detail of how agencies conduct their meetings. Their local policies can fill certain gaps. And so it is, of course, very important to review the rules and procedures or bylaws or what have you of each individual legislative body that you might want to appear in front of or monitor. So be it the Planning Commission, the City Council, the School Board, the Water Board, the Police Commission, et cetera. There, in some cities like San Francisco, may have a sunshine ordinance that may impose stricter, greater requirements than the Brown Act requires. And so again, always good to familiarize yourself, with that. Now, I saw some questions earlier about disruption of meetings in SB 1100. So we'll get into that a little bit. So unlike, I'm going to differentiate. If you're outside City Hall, for example, and there's an ordinance about, I don't know, police brutality or garbage collection or what have you. If you're outside City Hall on the sidewalk, and you have the right to protest almost, unlimited, you obviously have to stay on the sidewalk and follow the general rules about trespassing and so forth, but you have a right to stand outside City Hall and, chant and use your bullhorns and wave your signs and cause as much of a ruckus or not as you wish. In a traditional public forum, your free speech rights are almost unlimited. I mean, that's a separate topic, but I don't want to mislead you, but generally speaking, you have the right to protest as you like. Inside the room, inside the city council chambers or the board of supervisors, it's a very different matter. It is a meeting for conducting government business with certain public comment rights allowed, but there is no legal right to actually disrupt that meeting, to take more than your allotted time, to shout over others, to shut down the meeting. Some activists do make the choice to engage in civil disobedience and disrupt a meeting and try to shut that meeting down to make a larger point. This has been done, in various settings. For example, in the city of National City, just south of San Diego, there were protesters who disrupted the council meetings. They demanded answers about the police killing a National City resident. And that is I'm not here to comment one way or the other. That may be a moral right or a moral duty. Some see it as a moral right, a moral duty to engage in civil disobedience for some larger goal. And there's a whole theory and practice of civil disobedience as a protest tactic or protest strategy. I'm not here to comment on that one way or the other, but as a matter of what is the letter of the law, there is no legal right to do that without some legal consequence. And people can be removed from meetings. People can sometimes be arrested for doing so. I'm not condoning this one way or the other. I'm simply reporting to you what the law is on this area. Now, this gets to specifically a new law called, this was SB 1100.
Apologize.
Yeah, no problem. So,
getting a little ahead of ourselves. Let's talk about SB 1100. This is a great topic. Thank you.
So previously, before this new law last session, the Brown Act would allow a presiding member to clear the room, to declare the meeting has been disrupted under certain circumstances, have the room cleared entirely. And that's obviously problematic because it, shuts down the meeting and it removes the right of the people to hear and participate. What SB 1100 does, and this is now codified in the Brown Act, is that it allows the presiding member to order that a single individual be removed if that individual is genuinely disruptive. Now, it's not just a matter of being a little annoying. It's certainly not a matter of objecting to the content or viewpoint of what the person says during their public comment time. But if they are genuinely disruptive, i.e. going over their time, shouting down other participants, refusing to yield the floor and so on, they can be removed from the meeting if they are first warned that what they're doing is disruptive. They do not then promptly stop the disruptive behavior. At that point, the presiding member can direct, the police or sheriff or sergeant at arms to have that person removed from the meeting, for their disruptive behavior. Now, the one exception to the prior warning requirement is if someone is actually using force or making a true threat to use force, no previous warning is required. So, as I said previously, this is not a blank check for mayors or board presidents or presiding members to silence people simply because they disagree with their viewpoints. It really has to be limited to actual bona fide, genuine disruption that is making it impossible to continue the meeting.
David, there's so much interest in teleconferencing. Quickly, folks ask who polices the Brown Act. Folks have mentioned reporting violations to the DAs, who can, of course, investigate. Can you just talk briefly about your right as an individual to go to court, and then let's get into teleconferencing?
Sure. So the Brown Act has a couple of different paths to enforcement for different types of violations. As a general matter, any member of the public can raise a Brown Act concern, and they can do this in one of two ways. They can simply complain to the district attorney for the particular county in question. Every district attorney of every county is empowered to investigate Brown Act violations and take civil enforcement actions against local agencies that violate the Brown Act. Whether they will or will not do so is a matter within that particular DA's discretion, but you are certainly free to complain to your local DA, and some DAs have been very active in either filing lawsuits or sending letters to local agencies, be it city councils or school boards, that are violating the act. So you can certainly complain to the DA. You can also go to court yourself, but there's a couple of requirements on that. Before going to court, you typically have to send a letter to the agency explaining what the violation is and asking them to fix it. That's what's called a cure and correct letter or a cease and desist letter. Now, I want to differentiate between cure and correct and cease and desist because those are two different concepts. And this is a nuance I think that's often lost in talking about the Brown Act. Some Brown Act violations give you the right to go to court and ask the court to declare the agency action, the vote, null and void. So for example, if the city council votes on an ordinance that was not on the agenda, that is the kind of violation that can allow a court to declare that ordinance null and void. Before going to court to set aside that kind of vote as null and void, you have to send a letter to the agency. It's called a cure and correct letter. You tell the agency, this is what you did, this is why it was wrong, and you need to fix it. And they can fix it. If they decide to renote that item on a future agenda, say, all right, you're right, we'll put it on the agenda properly, we'll give the public an opportunity to be aware and comment. And if they cure the violation that way, they fix the problem and you can't go to court. But if they refuse, then you can go to court and say to the judge, they passed an ordinance, it wasn't on the agenda, that's a Brown Act violation, you have to declare it null and void. There's a whole nother set of Brown Act violations that you can go to court over, but you can't get the court to declare the ordinance null and void, or the action null and void. So the most prominent example is public comment violations. Let's say, for example, there's an ordinance, proposed ordinance. It's on the agenda, it was properly noted. The public is fully aware it's going to be discussed at the next council meeting. You go to that council meeting, they vote on it, but they say, well, we're not going to let you have public comment on this. We already talked about this. No public comment. Sorry, too bad. Now that's a Brown Act violation, and you can go to court over it, but the court does not have power to set aside that ordinance as null and void. What the court can do instead is declare that the agency violated public comment rules. The court can order the agency not to violate public comment rules in the future and potentially award attorney fees to the successful plaintiff. But for something like a public comment violation, the court cannot declare the ordinance null and void. Before going to court on this kind of violation, you have to send what's called a cease and desist letter, which is, like a cure and correct, but it says, this is what you did. You violated public comment rules. Stop doing it. Don't do it again in the future. If the agency responds and makes an unconditional commitment, you're right, we're bad, we won't do that again, unconditionally, we promise, and it complies with the letter of the statute, that would solve the problem in the court's eyes, and you would not be able to go to court. If they refuse your cease and desist, you could then go to court.
Thank you, David. There are follow-up questions about this. A couple folks noted there are just too many questions for us to get to. We want to definitely answer.
Key point, does a cure and correct have to be in writing?
Thank you.
Yes, it must be in writing. Now, you could potentially present it in person. Typically, it should be mailed in, certified mail. There are strict time limits on this and when it needs to be done. So it's a very short clock. I would refer you to the language of the act, refer you to our Brown Act primer on our website for all those details. But yes, the cure and correct and the cease and desist must be in writing. And that is baked into the statute. That's an absolute requirement.
Perfect. Thank you for answering that. Okay, let's get into everyone's, this is just all kinds of questions about the law changes over
Right.
remote participation for both the public and
Sure.
officials.
So
Thank you.
obviously, historically, before we had this kind of technology, all the meetings were in person. It wasn't a question. Now that we have things like Zoom or teleconferencing and so on, this technology exists and can be used, and it can be used properly or it can be abused. And so obviously during the COVID-19 emergency, the governor signed an executive order allowing agencies to sort of dispense with in-person requirements to protect public health. That's kind of winding down now. And I think those states of emergency are technically due to expire soon if they haven't already. So a lot of agencies are back to meeting in person. And when the legislative body meets in person, it may, but it is not required to provide remote access to participants or audience members. Certainly the Brown Act does not prohibit them from doing so, and we think they certainly should, and that would maximize the ability of the public to participate either in person or remotely as they see fit and as they have access to do so. But under the letter of the law, if the body is meeting in person, it is not compelled or required to allow a remote viewing or participation option. Now, when can a legislative body operate entirely remotely and not even allow in-person attendance? Only in very limited circumstances. One, the governor's declared a state of emergency and there's been social distancing measures imposed for public health, as in COVID-19. If the state of emergency ends, the legislative body can make specific findings every, I think, 30 or 90 days to continue with remote only meetings. That particular rule is going to sunset in 2024. I don't have data on how many bodies or agencies are actually doing that right now, but it is an option under the statute. And again, the statute on point, this is linked in our Brown Act primer. We're going to be posting some more materials on our website. For those who have more detailed questions, I certainly encourage you to read the precise language of these provisions because they are a bit technical and convoluted. If a legislative body does operate via teleconference only, in other words, let's say they're not meeting in person, the meetings are entirely remote, everybody's zooming in from their home or office and the meeting's entirely in the cloud, they must do a couple of things. One, they must provide a means for the public to participate remotely in real time via Zoom link, via telephone call, teleconference, what have you. Two, the meeting agenda must specifically say how to do that. So if they're going to meet entirely virtually, entirely in the cloud, they have to let you have an option to participate remotely, and they have to tell you how to do that in the meeting agenda itself, which again must be posted typically at least 72 hours in advance of the meeting. We didn't discuss agenda posting requirements. I don't recall. Typically, historically, they had to be posted like on the bulletin board at City Hall, so to speak, like a location available to the public. If an agency has a website, which I think virtually all do these days, but if they have a website, they must post the agenda on the website as well. There are, I think, accessibility requirements and ADA requirements and so on. I won't get into all those nuances. They're baked into the code. But agendas, typically, there are a few agencies I think that don't have websites. I've heard, but typically if they have a website, I'd look to their website for that agenda. But if all else fails, go down to City Hall or county building and look for the agenda posted on the bulletin board or what have you. So there's another new law that allows not just allows what we call hybrid meetings, in the sense that, let's say, an individual member of the legislative body or city council is not able to attend in person, but a majority of the council is. So this took effect January 1 of this year. For the first time, members of a legislative body do have the ability to participate remotely without being physically present, even absent a state of emergency. And there are limits on this. It has to be for just cause or emergency circumstances. There's a hard cap on the number of times they can do it, but this is allowed now under this new law. There are limits, obviously. So for example, you can look at the next slide. The body, the city council, what have you, must still have a quorum in person physically accessible to the public, let's say at the city council chambers. If a member of that body is allowed to participate remotely, then the public must be given the same remote access.
This is
So
obviously controversial bill
Yeah.
change. A lot of guests are raising the point that the flexibility here puts the member of the body first to be able to participate remotely, and then only then does the Brown Act mandate that the public has remote access in addition to their in-person access. That's a great policy point. It's top of our minds and the community we work with on policy reform. We share
Yeah.
those concerns, but we're going over the state of the law as today, as we know, as what's on
Yeah.
the book. Right.
Yeah, as I said, I'm reporting, not endorsing the letter of the law here in all circumstances. So that's a real quick snapshot on teleconferencing. How I want to pause for a minute. Are there any quick questions we should get into before I turn this over to Monica? And Jenny, do you see any sort of themes that we want to address right quick?
There's so many questions. I think the highlight here is all of your great experiences you're having with an individual city council, board of supervisors with very specific facts right into the legal hotline. We've been dropping that link throughout in the chat. These questions will just require some more research. But to help you get answers to some of these questions are coming up that are specific about closed session, additional facts about public comment, consent calendars, things like that. I think Monica's presentation here on how to use our resources will be helpful to you after this very short webinar where we can't get through everything. So why don't I ask Monica if you could just share a little bit with folks about how to use our free resources to follow up after this, since we just can't cover everything.
Sure, and this is just a snapshot of what's available on our website for anyone to use. The first thing I wanted to draw your attention to is our Brown Act primer. So when the slides come out, you will be able to click on the blue link right there, and it'll take you to the page where you can download the primer and save it on your computer for yourself. You can feel free to share that. Over here, I've got a picture of the table of contents, and it just goes through some of the topics that we cover in the primer. It's about maybe 12 pages long. So it's, kind of a brief overview. It'll cover some of the same things as David talked about today, but just in a little more detail. So that may be a helpful place. You can search through it if a question comes up about an agenda or about closed sessions, which I know is a popular topic. So feel free to download and use that resource and reach out to us if you have any problems accessing it. I'm happy to share it. Another resource available on our website is a sample cure and correct letter. So you can feel free to use that as kind of a framework for drafting your own letter. Again, the letter just needs to say, I think there was a violation on this date, and here's why. And, there's some more details in the letter on the website, and that'll be the same. The blue link will take you to that part of our website where the letter is as well. And then a third resource, a very popular one, is our legal hotline. It is totally free to any member of the public. You can write in with your questions about open meetings, which we've been talking about today. Any public records requests, questions, we're happy to talk to you about those. Access to court records, which is kind of a different bucket, different set of laws, but something that we're also, happy to talk to you about. And just general First Amendment issues, your right to protest. I saw some good questions in the chat that, we'd love to see in our hotline. And those hotline questions go to the inboxes, mine and David's. And also we sometimes have a law firm that helps us out with answering those as well. So you'll hear from one of us. And please feel free to flag that you came from this presentation. We'd be happy to know that. But anything we don't get to today, feel free to submit a question to our legal hotline. It'll have more space for you to include details and things like that. Oh, Ginny, I think you're
Thank
muted.
you so much, Monica.
Thank you.
Lots of great feedback here that people are bookmarking these resources and they're looking forward to getting the slideshow presentation emailed to them where they'll have these links in case they missed it in the chat. The chat will be attached to the video file that will also go out after the meeting. Great questions, everyone. David, any final thoughts about what you're saying, the common concerns and questions before we give our closing remarks here?
So I was trying to respond to a few questions in the Q&A in writing just now while Monica was talking. I'm sorry we couldn't get to all of them. A running theme I hear a lot, I've seen it in the questions today, and I've seen this in our hotline generally, is what about consent calendars? You know, a lot of governing boards will have a so-called consent calendar on the agenda, let's say 5, 6, 8, 10 items that they might vote on in a lump without necessarily holding discussion on any given one of those items. And I've heard questions about, can they do this? Is it legal? What right do I have to insist that something be pulled off the consent calendar and submitted to full debate and discussion? And I'm sorry I don't have a really good answer to that, because as far as I know, the Brown Act itself does not address the question of consent calendars. That is something, as far as I know, that is subject to, you know, local agency practice, perhaps provisions of the government code outside the Brown Act, and we can look into that potentially, but it's not in the Brown Act itself. And I know consent calendars are subject to enormous potential for abuse. City of San Diego about 10, 15 years ago had a massive public pension underfunding scandal, that much of which derived from votes and actions taken on city council consent calendars. So this is a subject, you know, near and dear to my heart personally. It's a huge problem. Some agencies may allow or require an item to be pulled from consent calendar at the request of a member of the public. Other agencies may say any board member or any city council member can pull it from consent calendar, but that's just not something that the Brown Act itself addresses, for better or for worse. You know, I'll look into whether we have a better answer and see if we can post that on our website or in hotline questions, but nothing in the Brown Act itself regulates the use of consent calendars.
Thank you, David. So much great information. I know it's a lot and so many questions we didn't get to. I just want to give a shout out to some of other organizations who joined this call and are offering their resources and expertise. ACLU of NorCal and SoCal has representatives on who are also open government champions and experts offering to connect with folks. No introduction is needed to the ACLU. We also work a lot with community groups and associations like SBJ chapters, California News Publishers Association. So we're all working together to try to make sure we get these educational resources out to folks who are trying to engage in public meetings. I just wanted to give a shout out to those groups who are joining us today. Okay, Carol and I have some business to discuss here. First, the First Amendment Coalition is a 501c3 nonprofit. We do this for free because donors empower us to do that by making donations. I wanted to share that information with you. We have a very generous community. Many of you have raised funds or donated directly, and thank you for that. Carol, what would you like to say on behalf of the League?
Oh, thank you so much, first of all, for coming and sharing this valuable information to us. I would like to point out that the League of Women Voters is a member organization. You join at your local level. That automatically makes you a member of the League of Women Voters of California and of the US. And at all three levels, we are interested in empowering voters and defending democracy. Open government laws are very much a part of that, and we are in the mix when it comes to dealing with advocacy on those issues and education, such as things like this. Great slide there. Join us at lwvc.org. Join. Also donate. Nonprofit organizations such as ours and the First Amendment Coalition live and breathe on donations. And with your help, we can continue to bring this great information to everyone who needs it and wants it. We need your help. So with that, I thank you very much for spending your lunch hour with us and urge you to bookmark the First Amendment Coalition website, send in your questions to their hotline, and think of us when you're making donations. Thanks very much.
Thank you, everyone. Thank you, Carol.